United States immigrations. The United States of America immigration. So, what every IT recruiter must know. So, US candidates. All the candidates you recruit from the United States will fail into one of these three categories of employment. So, now we will know about employment types. So there are three types of employment types. One is 1099, W2, and Corp-to-Corp. So the first one is 1099. 1099. In order to use this mode, the candidate must be incorporated, meaning must have a registered company. Many individuals, particularly US permanent residents and US citizens, sometimes prefer to work as solo consultants or take their wages on 1099 basis to take advantage of various tax breaks. That is, the companies pays their compensation, technically not the same as salary, and report to the US Internal Revenue Services IRS what money was paid to the individual, and the individual is responsible for paying the various various taxes like federal state taxes and the local social security, FICA or Medicare directly to the IRS. To minimize these risks, the companies normally ask the individual to be at, at least incorporated, that is, have his corporation, and all the money is paid to the corporation. So, in this case, the candidates like who are like US citizens or permanent residents, they need to have their own corporation for paying taxes to work on 1099 and W2. This type of employment is what the vast majority of the people see. That is, the company takes care of everything and gives the employee a paycheck. Along with this, there are usually additional benefits such as medical, dental, vision, life insurances, and retirement plans, tuition reimbursements, vacation, etc. So so here like W2 again into categorized by two ways. One is like W2 hourly basis and W2 salary based. So W2 hourly basis, like it means the employee gets paid only for the hours worked and no paid holidays, etc. So W2 salary based, it is it is with benefits like paid vacations and holidays, etc. And coming to second one, Corp-to-Corp. In this type of situation, the company will pay another company for the services of its personnel. Most of the subcontracting relationship use this type of an agreements. This is method is used when the candidate that matches your requirement actually works for another company. He is temporarily deployed by our company. After the project is over, he goes back to his previous company. His real employer pays the salary to his and not us. This happens when another company holds the visa, typically H1B visa, and he cannot be employed by anyone else. In this case, the business is transacted from corporation to corporation, hence the name Corp to Corp. So employment types with reference to work permits, like candidates recruited within United States are required by the U.S. laws to be authorized to work or possess a work visa. This is enforced strictly, and corporation found violating the law are personalized heavily. The IT recruiters are required to check on the candidate employment eligibility. So generally, the type of work visas, like citizen. These are born in US or later become US citizens. They do not need a visa to work. Their US passport is the authorization. They can work for any employer with no restrictions. And the second one is permanent resident, like green cards. Like these are commonly referred to as green card holders. They can work for any employer with no restrictions. And temporary visa holders, these candidates are typically on H1B visa and do need a sponsor to work for an employer. An employer has to sponsor the visa for the employee before they being work for us. Work permission visa types. The US laws on work permit and visas are complex and require a professional to interpret and take necessary action. This section is for the benefit of an IT recruiter to better understanding the various visa categories, so that proper decision can be taken with respect to recruiting activities without wasting too much time pursuing difficult to handle visa situations. So work authorization visas, like F1 visa, H1, and a TN1 and L1. So what is F1 visa? International students apply for this visa to come to the United States for higher studies. At the end of their education, these students are allowed to obtain permission for a 1 year practical training, PT, also called CPT or OPT, denoting curriculum practical training and optional practical training. A simple paperwork will authorize the student to work on F1 part time. For an employer, a simple paperwork will authorize the student to work on F1 part time for an employer. This visa status is also beneficial to the student since the tax consequences are lighter. Certain types of taxes does have to be paid. This kind of visa holders can work for any employer and do not need any sponsorship as well. It is easier to hire a F1 students. It is a lot harder to market them for IT staffing engagements. Since the students are inexperienced compared to the rest of the market candidates, these candidates certainly understand culture and language better by virtue of living in US for few years, but do not possess the technical expertise. And the second one is H1. This is temporary work authorization provided to skilled workers. In order for a person to obtain an H1, a company must sponsor them. There are two types of situations. Fresh H1B meant for a candidate residing abroad, and H1B transfer meant for a candidate already residing in the United States. The quota for H-1B applies to fresh H-1B candidates only. The candidates living abroad who are H-1B beneficiaries are required to first receive an approval from the USCIS and then take the approval package to the US consulate for appropriate visa to travel into the United States. The visa step is normally automatic. However, the US candidates at times override the USCIS decision and deny visa if they have any disputes. Most rejections go without any explanation. Currently, a total of 65,000 H-1B visas can be issued in a year. And a dependent on H-1B visa holder requires an H-4 visa, which does not authorize the person to work in the United States. And TN1, the United States of America signed an act called North American Free Trade Act, NAFTA. This act allows people of Canadian origin, citizens and permanent residents of like a Canadian origin, to work in the United States under TN1 visa. This is a simplified paperwork process, and the beneficiary can obtain the necessary work permissions within a day or less than a week. And L1 visas. This type of visa is given to employees working in a foreign country and later transferred to US to work for the same company. So permanent residency process. The term green card is common name for the permanent residence card, permanent registration card. This card is awarded to legal permanent resident of the United States and is evidence of this status. The color of the card is not green, but in fact pink, although it was green a year ago. Even today, the team green card is still used by both government officials and the public. Visa process. Upon approval of the work permissions, a candidate residing outside of the United States is required to obtain the necessary visa to enter the country. The petitioner or their attorney will send the necessary documentation to the candidate. The candidate is expected to schedule an appointment for visa interviews and obtain the necessary approval.